Hi, thanks for using My Court Coach. I'm Jalen and I'm going to be your instructor as we navigate through the form Request for Order, the FL 300 form. And this is only under the context of a temporary emergency basis. So if you already have a temporary emergency order or you are requesting a temporary emergency order, then this video is applicable to you. So if you've already submitted your ex parte application to the court, or you are going to submit your ex parte application, your emergency application to the court, and you have decided to also complete these forms as a supporting document to your application, then this is what you would need to do. You would need to make sure that the court, or that your whatever it is that you're requesting child custody and visitation, spouse support, attorney's fees, domestic violence, and child support and property order, or some other order like selling the home or issuing a passport. And those are the reasons for your temporary emergency orders. If you're requesting the court to change any existing custody orders, then you would go ahead and complete the child custody and visitation section, or child support, or domestic violence, or property control. So this is just going to be dependent on what the current orders are. If this is your first time completing one of these, then you would not check off the box of change, but you would check off the remainder of the boxes. So this ties to your emergency application, and if the emergency application is relating to child custody and visitation, then you would also check off these boxes. You'd write the name of the other party, and you would actually leave this part blank if you have not gone to your emergency hearing. If you did already go to your emergency hearing, then the court will fill this out for you at the time of your emergency hearing. And the reason being why is that they've already granted you temporary emergency orders, and they're having you come back a second time, and that second time will be listed in this box right here. Now there is this section, the court order, and it says for court use only, so do not complete this, but I do want to alert your attention to the responsive declaration for the request for order form must be served on or before. So if your hearing is going to be a week from the time that your emergency hearing is set up, then the other party is likely to request that they're able to prepare their responsive documents by a certain date, because there's statutes that's required in order for you to complete certain things by a certain deadline, and you wouldn't be able to meet those deadlines since everything is being expedited. So keep that in mind. The other thing as we go through and fill this out is the restraining order information. So you have to notify the court of the restraining order. You'd have to state who's the petitioner, who's the respondent, whether there's a criminal protective order, a family court order restraining the other party, so domestic violence restraining order, a juvenile restraining order, or some other type of restraining order, and that could be like an emergency protective order, for example. So child custody and visitation. So if your request relates to child custody and visitation, make sure you include their names, their date of birth, and whether you're requesting sole custody or joint custody, or maybe the other person should have custody, and same goes for the physical custody. And so legal custody, it tells you right here that it's the person who decides about the health and education of your children. Physical custody is the person who the children live with. So this has to just do with that, not visitation. It's who the child lives with or who the children lives with, and then same goes for legal custody. So this is what you're requesting. And then the orders that you're requesting is going to be specified on an attached form of some sort, and you can do attachment 2A and just create your own, or attachment 2B and create your own request, or you can just type it in this section right here. So the orders that I request are in the best interest of the children because And so you can go ahead and also fill this out. Since it is a temporary emergency order, this is the best place to type in the irreparable and immediate harm that would happen to your kids without the temporary emergency order being in place. And then this is a change from the current order. So there's legal custody, and then there's visitation. And so if there's existing orders in effect prior to you filling out this form, then you do need to identify that, like when it was actually entered, when it was actually filed, not the day that the court gave the order, but the day that it was actually filed, and then the date that the visitation order was also filed. And then you have to specify what those orders are currently before your request. Now, child support, you're not going to be really dealing with this in a ex parte or an emergency situation. So we're not going to review this because there is not any foreseeable circumstance where the court would grant you a temporary emergency order in a emergency basis. And then same goes for spouse support. This is not an area that the court would deem to be an emergency, so you would not complete this section either. Then there's something called the property control. And so since you are, if you are completing this form before actually having your emergency hearing, then you must check off this box right here. All right. So you're going to be requesting to have exclusive use, possession, or control of a certain property that you have with the other party, whether it's a house or a lease or a car, a boat, whatever it might be. You have to list what that property is. And then to take it a step further, you want the other party to make whatever payments that are due against those properties. So pay it to, like, let's say Wells Fargo for the mortgage amount, $3,000 due the first of the month. Something along those lines that you would go ahead and write that. So if you have already existing property orders, then you would need to check off this box and say that this is a change from the current order that was filed on blank date. And then you have to attach a declaration or an attachment stating why the court should make these change in the property orders. So you could state whatever is necessary, and really what the court is going to be looking for on an emergency basis is some damage to the property that's being caused by the other party. So you need to make sure that that is written in there, something that would require the court to take immediate action now, today, ASAP, versus a few months down the line. So attorney's fees and costs, very, very rarely will this be granted on an emergency basis. It's actually almost never granted on an emergency basis, so we're not going to review that section. The domestic violence order, for that to be granted on an emergency basis, that requires an agreement from the other party, and you wouldn't even be filling out this form actually if the court did grant it to you at the time of your hearing. But if the court didn't grant it to you at the time of your hearing and you're both in agreement that there's some changes that you want to make, and the court's not granting it at your emergency hearing, then yeah, you would want to go ahead and complete this, where you have the request for order hearing, you write the date that it was filed, you should write what you want to change or why you want it to end, and this is what you're asking the court to change and why you're asking the court to change it or end it. And if you need more space, again, you can just attach documents and just write the words attachment C 7EC and attach it to this document. But very rarely will the court actually grant an ex parte relief for a domestic violence restraining order. They won't change it just like that, especially if there's not an agreement. The courts would prefer to deal with that on its regular calendar versus having to expedite it, but you have to have a good reason as to why you need to expedite. And remember, the standard is immediate irreparable harm, and their restraining order prevents immediate irreparable harm. So you really have to have really good reasons as to why you want to change it sooner rather than later. Other orders can be like you're trying to sell the house ASAP, and because the other person's actions, for example, is diminishing the value of the residence, and we need to put this on the market ASAP. And so you could request that. Unlikely that the court would see that as an emergency, but you can, request it as your emergency pleading. But typically it's based off of custody visitation and then some property control there. So time for service. So if you are asking the court to, give you this second hearing date, or if the court wants to establish a second hearing date, then you should complete this as well, because you'd want the court to allow you to hand deliver or deliver in some fashion to the other party this form, especially if they don't even show up to your emergency hearing. So if they don't show up, or if the court does make emergency orders, you want to be able to have time to give the other party the paperwork. So you want to ask the court, okay, give me no less than X amount of court days. So court days are like business days almost, but the court doesn't observe all of the holidays. So you have to go on the court calendar and see what those holidays are, and that's maybe pursuant to your local rules. The hearing and date and service of the request for order to be sooner. And so if you are requesting that the court have the hearing to be sooner on your request for order, and this is again because you're filing this document with your request for an emergency hearing, then you are checking off this box, and you'd have to establish why you need it to be sooner. So this actually would be a good part where if you are asking for the house to be sold sooner rather than later, or the passports to be issued sooner rather than later, and just using the passport example, you've already bought your tickets with the agreement of the other party that you were going to go on this international trip with your children, and the other party said they were going to go ahead and release the passports or renew the passports, something like that. So you're able to purchase the tickets because you had existing passports, but you need to renew them in order to travel, and the other party just last minute says no. That's when your trip is around the corner. So that's a good reason to ask the court for some relief and to expedite that relief, especially if your trip is around the corner. That's just one example. So facts that are in support of everything that you're requesting, it really should just be what is written on your ex parte application, what is attached to your emergency hearing application. It should mirror this. And oftentimes I would just write ex parte declaration in support of my ex parte application and order. You can add that. But if you want to also have an additional attachment to this or duplicate the attachment to the declaration for the emergency hearing, you can certainly do that. Just make sure that you reference it in this box or label it attachment 10. Make sure that you date it and you sign it and you print your name. So that's how you fill out the request for order form. So because we have this temporary emergency order checkbox, we have to also attach this, because now we're assuming that the court is granting our request for the temporary emergency order. And if the court is granting your request for the temporary emergency order, then when you go and when the court actually processes this document, it's going to have a second hearing date, and this date is going to mirror the date that's also on this document right here. All right, and it says that the court hearing will be held on the request for orders form served with this order. So these documents go hand in hand after an emergency hearing has already been taken place, and it's going to be for one of these issues listed above. It's going to be to the other party, and the court is going to have to find that they need to prevent immediate loss or irreparable harm to a party or to a child to the case. They have to prevent immediate loss or damage to a party, to a property, or there is a set or change of procedures for hearing or trial. So that's, for example, if you wanted to reschedule a hearing and the other party is not in agreement and they didn't necessarily show up to that hearing, and you need some interim relief, some temporary relief between now and the time that you need to notify the other party for that rescheduling, then the court can find that that is a good reason to set an emergency hearing, because your hearing is just around the corner. So the court is going to order that the temporary emergency orders are going to expire at the date and the time of the hearing is scheduled, unless it's extended by another court order. So you have to, and if it is a child in custody and visitation order, you're going to list child custody and visitation. Now, this is not a child in custody and visitation emergency, then you're not going to list anybody. If it's just a property emergency, you're only going to list the property on the next page. But if it is a child in custody and visitation request, you're going to list the name, you're going to list the date of birth, and then the court is going to fill out whether they're giving you temporary physical custody of the children or who they're giving temporary physical custody to. The parenting time, the court is going to go ahead and specify the parenting time and make that an emergency order. If there's any travel restrictions, then the court is going to go ahead and restrict the other party from removing the children from the state of California unless there's another order specifying otherwise. So they will not be able to remove from the state of California. Can take it a step further and say that they can't remove them from the county in which the children reside, or they can't even leave the country. So it depends. Being that we're so close to Mexico, maybe that's something that would be, written in here too. So child abduction prevention orders, those also can be something that the court orders, and it says to check out FL 341B. But for today's purposes, that's what you would need to fill out so that the court can attach it to these temporary emergency orders. And so the court has to make what we call Family Code 3048 findings. And what that means is the court has jurisdiction to make orders. They gave the other party the notice and opportunity to be heard. And this is the country of residence. So the country of the residence of the children is the United States. And that if you or the other person violate this order, then you will be subject to civil or criminal penalties or both. Now, for property control, the court can give temporary use and possession and control of that property and basically mirror the information that you've requested in your declaration for the emergency hearing. And then all other orders not in conflict with these orders will remain in full force and effect. It's a very general statement. Basically, if the court has made any other orders, then those orders will also remain in effect so long as they don't conflict with these existing orders. And then any other orders the court, wants to make. So for, let's say, child custody and visitation, maybe the court wants to send the parties to a mediation, like having a mediator from the courthouse, help out with this particular matter, and perhaps would set one up in the future, or ask the other party to file something before they come into the next hearing. So the judge would go ahead and sign off on this. So these are 3 forms that you can complete as part of your request for a emergency temporary order, and you could either complete these before your hearing and just submit them with your emergency application, or if you wait for the day of your hearing and you decide to complete it right then and there, and the court can take those documents from you and sign off on the paperwork. But if you are specifically requesting child custody and visitation, then it's best practice to complete the FL 300 as well as the FL 305. If it's a property as well, it's a best practice to go ahead and complete these forms as well, along with your emergency application. Anything else, I think the ex parte application and order is sufficient. You wouldn't need anything more than that. And these are not mandatory forms, but they are definitely, again, best practice, especially in those circumstances. Well, we hope that you have found this helpful, and thank you for your time.